As I have discussed in the previous subunits about other evil practices like domestic violence, dowry demand, child labor, trafficking, prostitution, etc., there is another evil practice that has been continuing in India since decades. This evil practice is that of child marriage. So, hello learners, welcome back. I, PALLAVI SENGUPTA, a faculty member of National Law University, Odisha, am here with the final subunit in which I shall discuss the concept of child marriage and how the same practice can be stopped. Let's first look at the chief causes of child marriage. One of the foremost causes of child marriage is poverty. Parents from very poor backgrounds having many children in the family are often forced to marry their young daughters off at the age of 9, 10, maybe 11 years to older men who are often more than twice the age of their wives. The situation of these child brides is bad as they are expected to look after the children of their husbands begotten from the latter's previous marriage. Other times, these child brides are asked to fulfill the sexual needs of their older husbands. Since these children are young and immature, they are not able to understand the nature and consequences of marital relations and hence have to face expectations of which they have no clue. Now let me discuss the second cause, which is education. Lack of awareness and education is a very important cause that often helps in propagating the practice of child marriage. As the girl child is not sent to school but forced to stay at home and look after her younger siblings, she remains unaware of her rights. As nobody is there to guide her and tell her about the evil consequences of child marriage, she is forced to marry early by her parents. What happens is she remains unaware of the expectations and demands that would be made of her at her husband's residence. The next cause is that of patriarchy or local customs. One of the foremost reasons why child marriage is still continuing so vigorously today and why it is propagated with such pride is because of the norms of patriarchy. In many parts of India, child marriage has been going on for centuries, and the families in these regions take a certain sense of pride in solemnizing such practices and in justifying their wrong action with the excuse that it is a part of their custom and culture. They say that their forefathers had child marriages and they are only trying to follow and to preserve the same tradition. Often these people belong to rich and educated families and they even have the backing of local politicians and renowned businessmen of these areas who should know better and who are presumed to be ones who should not break the law and should follow the same. Because of the earlier mentioned reasons, child marriages have been going on and will continue to prevail until the people in the society understand fully what harmful consequences such practices in many cases have on the children who are the victims of these child marriages and subsequently result in certain other difficulties like the difficulty of teenage pregnancy, which has resulted in infertility and less number of cases wherein the mother survives. Now let's look at the legal aspect of child marriage. The prevalent law in India, as we know, is the one which talks about prohibiting child marriage and is called the Prohibition of Child Marriage Act of 2006, hereinafter referred to as the Act of 2006. This act aims to prohibit the promulgation and solemnization of child marriages in India. So who is considered to be a child for the purpose of child marriage? Any male person below the age of 21 years and any female person below the age of 18 years is considered to be a child for the purpose of marriage in terms of child marriage. So technically, if the bride is below 18 years or if the groom is below 21 years or if both are below the prescribed limit of age, then the marriage between the two will be considered legally to be a child marriage. What is the legal status of the Prohibition of Child Marriage Act of 2006? Before discussing the legal status of the Act of 2006, let me talk about the earlier law that governed child marriage and how the Act of 2006 is different from the earlier one. Pre-2006, child marriages were regulated through the Child Marriage Restraint Act of 1929, the main aim of which was to restrict child marriages, and the Act of 1929 nowhere talked about prohibiting the evil practice, which was taken as an excuse by the families to propagate child marriage by justifying the law. Now coming to the new law, which is the Act of 2006, as the title itself states, its goal is stricter as it talks about prohibition of child marriage and talks about the fact that it is to prohibit child marriage and not to restrain the practice of the same. However, in effect, this law has certain lacunae too, which I would be discussing hereinafter. When we talk about the Act of 2006, a child marriage is not considered void ab initio under it, but only voidable, which is at the option of the boy or girl who had been a child when the marriage was solemnized. So what is the difference between void marriages and voidable marriages? Void ab initio means that the law treats the marriage as if it never happened or existed. On the other hand, voidable means the marriage is legal until the relevant party approaches the court to get an order of annulment. Further, the party for the annulment has to do so, that is, approach the court within 2 years of attaining majority, after which he or she loses the chance to approach the court for the declaration of the annulment. It is relevant herein to mention in this context that there are few circumstances under which the law can say that there is a child marriage which is void ab initio. Now let me briefly mention about the punishments that are prescribed under the Act of 2006. The Act of 2006 provides punishment for firstly the groom if he is above 18 years and contracts a marriage with a child bride of less than 18 years. The Act also prescribes punishment for the family members if they give their children in marriage. In this context, a family member would include the parent, the guardian, or anyone who is in charge of the child who is given in marriage. Also, under the same Act of 2006, there is punishment prescribed for the one who performs or who conducts or even directs or even also abets a child marriage. The maximum term of imprisonment in the given cases can extend up to 2 years of imprisonment and a fine of 1 lakh of rupees. This is it for the module, or rather the unit on women and children. Hope you all have learned something about the concepts of evil practices when it comes to the dowry system, when it comes to domestic violence, when it comes to child marriages. You must have also learned something about juvenile justice and how these children who are the victims of societal crimes can be protected and the offenders can be punished. Let me tell you that it has been a great privilege in discussing these topics with you. Thank you.